All right, it's 7 o'clock and I'd like to call the meeting to order. And I guess the first order of business would be a roll call.
All right. Commissioner Subramanian is not online. Commissioner Master Batista.
Here.
Commissioner De Santoro.
Here.
Commissioner Walsh.
Here.
Commissioner Grady Benson.
Present.
Commissioner Cloud.
Here.
Commissioner Callahan.
Here.
Commissioner Gemsky.
Here.
And Chairman Schoenhorn.
Here.
All right. We're all set.
All right, there are no public hearings, but what we were going to discuss and I wanted to give everybody an opportunity to just weigh in on this is I had a meeting with the with staff as well as with the town's land use attorney, Bob DiCrescenzo, about going forward and the issues that were raised by some members about when applicants are not present, and worse, when they're not even on video, but they're on phone. And then there were some technical difficulties where we lost the actual applicant for periods of time. So I thought I would open it up this way because the discussion we had, basically it was kind of a compromise. We like the idea of hybrid meetings. We like the idea that that this is carried on the internet, that anyone can join and observe, even if they're not going to say anything. And any member who can't be present can join in and participate remotely. The issue that I think caused some issues was if the applicant is not here. And part of the reason that I was concerned is, as a board, we're not just a board that listens to the public. We actually are an adjudicative board, which means if people they're coming here and asking us to waive the zoning regulations, we make a decision that then becomes part of the land records. And if it happens to be an application that is controversial or has opposition, occasionally, not a lot, but we occasionally have that, anyone who's aggrieved can sue. So there's an issue of due process that has always been on my mind, and something that, at least in the 9 years I've been on, and I think Carrie been on longer than that, I don't think anyone has ever, certainly not successfully, sued the ZBA. I'm not even sure they've had grounds to even bring an action against the ZBA in court, correct?
Not since I've been on.
Yeah. So, you know, a lot of towns, you see a lot of these ZBA appeals. I like the fact that we never have one because we do our job and we follow the rules, and then there's no abuse of discretion. So when it comes to an applicant, we are being asked to review, just like planning and zoning, we are asked to review site plans. We're asked to review construction plans. And oftentimes, but not always, the applicant is a contractor, such as a swimming pool, solar company, a construction company building a house, or remodeling or adding on to a house. And it's, from my point of view, and from some of the other people who have expressed concern about it, you can't, if your applicant is not present, it's difficult to point to something specific on the plan that's up on the screen and ask them to explain this or that. And I'll use the one example from about a year or two ago where somebody wanted to put a solar array. And in what they did, if some of you will remember when you're on here, they used Photoshop to create fake trees, it looked like an oil painting. They say this is what it's going to look like, but it looked almost like a scene from a Monet painting, sort of a multicolored oil painting of trees hiding this giant ground array. So when it really comes down to it, I believe in making this as public and as open, as convenient as possible. But when it comes to applicants, it's my belief that they should be here. And that means here in front of us so we can ask questions, point to things, have them show us things, which again goes more to the issue of wanting to make sure nobody's going to later claim that there was insufficient due process. Anyone else other than the applicant can either appear in person or appear remotely. And of course, I will just add this. If there is a specific hardship why a person can't be there, they are ill, maybe there's, I mean, we could go remote if there's going to be a blizzard, for example, a snowstorm, we can go remote. But a hardship that would prevent the person from being there, then certainly if they give us enough notice, we could then convert that into a hybrid meeting and allow that person to appear remotely. So I'm just going to open it up to discussion. We don't have to go in any particular order. So my suggestion, and we're looking for, if not a consensus, certainly majority view on this, that we allow, as we've continued, everything is hybrid. Members appear hybrid if they wish, although I urge them to be here personally, because when I appear remotely, I can barely see what's on the screen, some of these plans, when there's a giant A2 survey and we're trying to figure out exactly where the lines are and where the proposed variance is going to be. But that the applicant needs to be present. If they can't be present just because of something other than a hardship, that they agree to postpone till the next meeting when they can be there. So that's my proposal. Just open it up for discussion.
Mr. Chairman, just really quick to interject, alternate Commissioner Subramani has signed on.
Oh, hello.
A couple minutes ago, I missed her signing on, so
Okay,
just for
so
the
now we have everybody.
yes.
All right, so I'm going to open it up to discussion, and whoever wishes to speak,
Where are we placing this preference?
it's going to be in the notice and in the instructions to the applicant.
Okay. Yeah, I'll throw out there, and I was speaking to, I forget to whom we were speaking about this, but as you know, John, in legal circles, we have the expression "for good cause shown." A continuance shall not be granted, but for good cause shown. And that's kind of the way I look at this, our policy is that the applicant should be here, but for good cause shown. And if an applicant can't be here because that applicant has to care for a sick child, a sick parent, just tested positive for COVID, whatever good cause shown it may be, then we exercise some flexibility. But otherwise, I think it's perfectly appropriate for us as a commission to put in our notices that our strong preference is to have the applicant here. Because I know there was one that even I did remotely. That was because of technical difficulties, it was very difficult to hear.
I remember. Yeah.
I just think if it's important enough to them, they should show up here.
Yeah.
They should be in person, present their case to us in person. Again, like
And
you
if
said,
it's-
if there's extenuating circumstances where they can't, that's will have to be addressed, but I think if they're filing, have something done in their yard or whatever, they should be here.
I have two questions. So before I was here, I attended a few meetings in the audience. And at one of the meetings, there was an applicant was here, and on the phone were two people from that person's office. And it was even difficult to understand them, the two people in his office. So when you say we expect or we prefer everyone to be here, does that include everyone?
Well, the presenters, let's put it that way.
Presenters, that's right.
Okay.
Yeah. I'm using the word applicant, but sometimes the applicant is represented by an attorney, for example. What's the name of the attorney that's in a lot of these land use cases that sometimes appears for applicants? He's
Ohad?
Yeah, Chris Hoheb. You know him?
Sure.
So
Bill Master Batistro does too, but whoever the attorney may be, if we put that in the notice, it sends a pretty clear message.
Yeah.
As to what our preference is, and I would think people would get that and think, oh, if I want my variance granted,
Right,
I better show up.
right. And then my second question is, who would decide if they do have a hardship?
I guess in the first instance, it would be the chair, would be me, because I consult every week with Garrett before a meeting about what the agenda is going to be, just like I think most of the boards in this town do,
Yes.
don't they? Yeah. But if I thought there was an issue, I would just reach out to people and, we wouldn't have a online meeting, but ask people their view. And if there was any question about it, then that's how we'd handle it.
Okay. that's-
So, John, you and I, you and I talked about this. I mean, I think that this is more of a clarification and codification of what we want to see happen going forward. It's not
Correct.
very far away from what we've been doing already, but we're making it clear through the notices, et cetera, et cetera. And to your point, if somebody really wants a variance, they should take the time, care enough to show up in person.
Right.
I don't think we're harming anybody by doing this, and I worried about, being punitive to individuals, but we're not doing that either. So I'm more inclined to support this if we're making sure that we're not being, overly harsh or judgmental punishment, that it's associated with not showing up.
Mr. Chairman, sorry.
Yeah.
Alternative Subramanian has her hand raised.
All right. Haritha, do you want to say something?
Yeah, before I get to the comments, I had a question first. So in any of the other municipalities in Connecticut, do any of them have similar language that we're proposing? Like, do any of them say they have a strong preference for showing up in person?
Well, I don't know if Garrett knows the answer to this, but I'll tell you, I look at the legal notices that are in the Hartford Current because I look to see what kind of rulings there are on similar kinds of variances. Most of the towns now do not have hybrid. They're in person only for the ZBA. And I was actually surprised when I saw that. Very few are even hybrid. Occasionally, there's one or two that are online still. I know that what is it, Inland Wetlands is fully online,
Still,
which, what's that?
yes. Still, yes, they're still.
Still, which surprises me, but I'm not them. So, so to answer your question, very few towns still are going hybrid when it comes to ZBA meetings. I don't look at other land use commissions like wetlands and planning and zoning. I just have looked at ZBA meetings from other towns that advertise in the legal notices of the Current. Does that answer your question?
Yeah, kind of. So from what I'm hearing, even if they do offer like hybrid hearings, they're not using the language special preference. Like that is something that we created.
Correct. In other words,
Okay.
you don't want to leave the impression that they can show up or not show up just because they don't feel like it.
Okay.
That
Because
would
one
se-
thing, oh, sorry, go
Go
ahead. Because I know one thing that I heard earlier in this discussion that I'm kind of scared about is this idea, like I see it, yeah. Like, is this idea that, if you really want your variance, you should show up. So if we say it is the preference of the zoning board of appeals that participation be in person, is that saying that they are less likely to receive a variance if they show up online?
I don't know if I can answer that question, but the bottom line is, from my perspective, all right, if I don't have my questions answered to my satisfaction, then I would either vote no or I'd abstain. And since they need 4 positive votes to approve any variance, because again, I'll point out, this is they're asking us to not just vary, but change or not violate, act not in accordance with the zoning regulations of the town, which will allow anyone who, either a neighbor or anyone who might be aggrieved by that, to sue us in Superior Court. Any decision of this board is subject to appeal to the courts. We are the appeals board. And the other thing that I didn't talk about is that when we're dealing with applications from zoning enforcement actions, those have to be under oath. We are hearing witnesses and deciding on their credibility. And I'll tell you, as a lawyer, as a trial lawyer, I've done hearings where they're remote. You can't really make a credibility determination based on on just seeing someone's face. You need to see body language. You have to hear them. You have to talk to them directly. And since they have to be under oath, I don't even think one can still swear people in remotely anymore. That was an emergency that was allowed during the pandemic. I don't know even if it's still allowed. So I just bring that to your attention as well. So when we talk about I want to be clear, when we're talking about the preference, we're saying that the applicant needs to appear, right? Just the way it's written now, it looks like it's the preference that everybody participate in person. We're going to use language that the applicant should appear in person unless there's a request in advance to be excused. That's how I.
Okay, so does that mean we're shifting the language from being preference to we are requiring the applicant to be in person unless they tell us beforehand?
Yes.
That be
Yep.
okay.
Okay, Kate, while we're talking remotely, do you want to add something?
I don't think she was done.
Oh.
Yes, actually,
Sorry, hold on. Are you done, Haritha?
oh, sorry.
No, you can come back to me. You
Okay.
can go to Kate. Yeah.
No,
All
go ahead, Haritha, finish up what you were gonna say.
No, I'm still thinking. Go ahead.
Okay. I'm agreeing with what I've been hearing. I do think the applicant needs to be there unless, there's extenuating circumstances. Because I find it very difficult to interact with someone who's on a little screen. I know it happened with there was a case, can't remember which case it was, but the woman was sick. I mean, obviously she had a reason for not being there. But then I don't know if she was sick. No, she said she wanted to go home because it was late at night. She
Weather
was,
was bad.
It was a swimming pool. Wasn't she from a
It was a
company?
swimming pool, yeah.
yes, as a matter.
The design person from the swimming pool company.
It was gonna be
Right.
hard.
Yeah,
It was a far drive.
from Granby.
Yeah, and I found that difficult for me to make a decision on that. Obviously, it happened. I see the pool's in, so. But yeah, I agree with what's been said in regard to changing the language to instead of preference, that it's required, but that if there's extenuating circumstances, of course, they could come hybrid. That's how I feel about it. I think it's
I wouldn't even, so extenuating, so I would just say for good cause, they
for
can.
good cause. Okay.
Yeah, that's fine.
But then the cause becomes this kind of nebulous thing. Like how do we define that?
Well, I don't know if we can, because there is a difference between somebody being sick and having childcare issues, but both of those in my mind would constitute good cause,
Agreed.
right?
Kate, are you done? Sorry.
I am. Thanks for asking.
Okay. Do you mind if I go? So I am of the mind that if we want to include language that's a preference that we have people here in person, I think I'm fine with that. I think requiring that someone be here in person, from my experience, there's only been one issue where there was a person who was on the phone or was on Zoom, but not showing their face, was not on camera. But I think that we are here to serve the residents of the town. And I don't want to limit participation of any applicant and put in a hard requirement that they're here in person if they can't be. I understand the qualification of if there's issues, but a lot of these issues could pop up at the last minute and they may not be able to give us the amount of time that we're requesting that they be here in person. I think we can say we'd like to have people in person. I think, although I would say that this language was all instituted before we have had this discussion as a board. So this was kind of moved ahead without kind of discussion anyway, but I think having a hard requirement in my mind is not consumer friendly, and I see us as consumer representatives a little different than your viewpoint about us being a legal entity. I know we have legal responsibilities, but not all of us are attorneys on the board, and I feel that it is a representative in the town. It's my duty to listen to people, whether they can be here in person or on camera. I think we can put in qualifications that if they're appearing on Zoom, that they have to appear on camera, they have to state their name for the record. But I am opposed to putting in a hard and fast requirement.
Is there anyone who hasn't spoken?
Yeah, I just want to expand on that. I don't think we're going to do a hard requirement.
That's what I heard. That
Well,
we're gonna put
I
in a
think we're
requirement.
under certain circumstances, I would say we would be very open-minded to having the applicant call in or do a Zoom meeting. So I'm very open-minded for those special circumstances for applicants. I'm going to take it a step further and say that us as a board should be here more importantly, okay? We're elected officials. We all put a sign in the ground. And I say, if we're going to serve our constituents, we're not going to be doing it from home. We're going to be doing it from here. And quite frankly, if you can't make a meeting, then you can't make the meeting. That's why there's alternates elected to these boards. So that's how I feel about the board. I'm doing a service to the public, which we were elected to do. So that's how I feel about the board. And more importantly, with the technical things, I mean, just in this last couple of minutes here, we were straining to hear the conversation, and then we get lost in, okay, you go. And I think we lose a lot of interpersonal skills of hearing the applicant or the board to the applicant. We miss these nuances of how the application's going in the presentation. And I feel the one-on or the board to applicant interaction is very important in person. And I think we lose a lot of that when we have the applicant on Zoom or something like that. So I agree with having special circumstances for applicants, but same to the board too, that we should be.
I agree 100% about that. The commissioners should be here in person. But Garrett said about 20 years ago, there was a decision made.
So it's been, so it's been a long-standing FOI that commission members can call in for a meeting, conference call. I'm just covering the bases. So, because part of the discussion staff had with the chair and the town attorney was that it can't be a requirement for the board because the FOI has long recognized that commission.
Oh, yeah.
I'm just.
I was going to say that. Attorney DiCrescenzo specifically said that it's always been the case that a commissioner can call in or Zoom in. And I don't want to get rid of the video link, the Zoom link. I don't know if there's seldom people watching, but they could if they wished.
I agree with you on that, John. I agree with you. The main reason I like this Zoom is because the general public can participate and watch and see an application or a neighbor's application. And I think it's a great tool for the general public, for any board in the town and in the state, national, you name it, for participation. I think it's a great tool. That's maybe, it's a personal preference that I think that we all should be here, but if it's a statute or law, that's it, I get it. But that's generally my feeling on it.
May I add something?
Yes.
All right. So I wanted to address like Peter's point and then also Liz's point. So I'm actually extremely glad that we have precedent that allows commissioners to sign on online. That also makes it more accessible for people in elected office. Like, I'm not signing in from home, I'm signing in from school. And that helps get young people involved. And then, I do understand that having that interpersonal connection is incredibly important. We also live in a world where hybrid meetings and online meetings are commonplace. It's 2025. And I think that is something that we have to adapt to. When the world adapts, and I think that's one of the best things that's come from COVID, is this increased adoption of online interfaces to help increase accessibility. And to address Liz's point, I completely second what Liz says. I understand we're an elected board, and I understand there's legal liabilities, but also that's our job. And I'm not going to, be offended if someone doesn't show up in person. They're still putting in the time, they're still putting in the work to show up and whether that's online, whether that's in person, that still means a lot to me. And again, like in the past, we have had issues virtually, but that's mainly been they didn't have their cameras on, they had unstable connection, and I think that's what we should be focusing on, like quality control of online participation. So if you do choose to participate online, you got to make sure that those things are intact. I also think that, like, I hear that we have special exceptions, but this has been a long, and when you're fighting for accessibility, needing to ask for permission beforehand to access needs always makes it more difficult, especially if there's something that comes up last minute. I would rather just it be an open option for everyone, and that's the most accessible option, because otherwise we're just adding extra hurdles to me for no particular reason.
So what I'm hearing though is we're not going to have a full consensus, all right? So if I just want to sort of summarize here, because I think we've all had a chance to express our view. So we have two individuals, and it's Liz and Haritha, that would want to make it so that someone used the term consumer friendly, and I'll make reference to that because I take issue with that's not our job. But two individuals would want it to be that people can show up or not show up in person, and it would be the same. And there should be no negative connotation or I can't think of another way. Presumption against that person if they don't want to be here in person, that we're in 2025 and in person is so 2021. I don't know. But so that's my understanding. And for the rest of the people here, they either agree that that there will be exceptions, but that the notice to applicants, not all persons like the old notice says here, but that the applicants shall be present unless they request an exemption, for good cause, that they can be appearing remotely. And I just want to make sure the rest of the people that are here feel that that is the preferred way to
Yes.
go.
Yes.
And Judge, if they're not granted that, they can reapply for the next month.
They can,
So-
it'll be postponed till the next. meeting.
Yes, so that's
Right.
just something to cover. So statutorily, so if you deny an application, unless the application is substantially different, the applicant cannot reapply for 6 months.
Unless,
No. So
Saying come back next.
right,
time.
so in the
Yeah.
state statutes, the public hearing can only be open for 35 days. So generally, you do have that time frame for when you open the hearing to the next meeting. It's usually less than 35 days. I think our long one is right now, because I think I counted between the February meeting and this meeting, it's 31 days. So we'd be cutting it close if anything came up. But there is the time available to the board to continue it to the next meeting. It's not necessarily that you have to hear and decide on a application in one night.
but if the applicant requests the continuance, the clock doesn't run, right? Doesn't that?
No, it does. It's a statutory restriction of, it's technically it's 65 days to open a public hearing, 35 days to hold a public hearing, 65 days to decide on the public hearing. That usually applies to other boards that set the public hearing. Staff sets the public hearing for ZBA. So that 35 days starts at the first meeting when you open the hearing.
All right,
It's
well, what about
advertised.
opening it and continuing it to the next meeting?
It starts that clock on the 35 days. There's the option for extensions. So
Yeah.
theoretically, if you had a very controversial application and you felt that there was reason to grant the variance, but you needed more information and it took time to get that information, they can request extensions. It's there's up to 65 days total, or 265 days that can be allocated at any point in that time frame. It's generally to protect the applicants, so that way the board can't just delay voting. It kind of forces you to make a decision, which is generally not the case in Farmington. I'll say there's a reason that it exists, because there were towns long ago that just didn't vote. and just had kept the application on the agenda. So I'm just trying to go through the whole process. So 35 days starts the clock. Even if it's continued to the next meeting, you're still starting that 35 days. If something came up at the next meeting, you need to continue it to the following meeting, the applicant would just request an extension to extend the public hearing to the following meeting because we'd be on that 35 days.
Well, let me ask this question, because I thought this had happened once. There's a public hearing on our agenda. Nobody shows up. We don't know what happened. Maybe someone was on an airplane and didn't land in time. Don't we table that hearing? We don't deny it just because they're not here, do we?
You would table it to the next meeting, but
Yeah.
statutorily that clock starts as soon as the meeting
All right,
starts.
so we could have it
We'd
the
have
next.
35 days.
Yes.
And if we're close to that, we're allowed to call a special meeting if necessary, so we don't run out the clock, right? We
Yes.
Did that with the McDonald's or Wendy's application a few years ago. You had to have a special summer meeting that you called because of the Wendy's
remember the
over by the
Wendy's.
mall.
I remember the Wendy's by the mall and it was the driveway, but I don't
Yeah.
remember the special meeting. I don't disagree, but I just don't remember.
And usually it's something that if the applicant consents to an extension, we can do it post the expiration.
Yeah.
We do that with, so like another time frame, subdivision maps have to be filed within 90 days, but you can request a 90-day extension. If the meetings don't line up with that 90 days, we're not holding a special meeting just to grant the 90-day extension. We'll just do it at the next meeting post.
And am I also correct that if it's denied with the permission of the board, it can come back within the 6 months, correct?
Yes, I would add that we would do that at a meeting. So
Yeah.
it would be preferred to just continue it as opposed to denying it. They come back the next month, you decide whether you'll accept it or not, and then we have the hearing at the following meeting. So now you're at
Okay.
3 months.
So I don't want to hold anybody up longer. Does anyone else want to say anything? Are we kind of in agreement then that that's going to be our general procedure going forward?
Can I just insert something? It's Kate. I just wonder, one of the issues with some of the online stuff was one, camera off, and then, tech issues. Is that something that needs to be included in some of these instructions, that if you're coming remote, you have to have camera on, and that, you're checking if we have problems with transmission, that your case will be, delayed to the next meeting or something like that. I think there needs to be language like that, because otherwise we're going to be in that situation again.
Well, my gut feeling is you don't want to create more issues by giving additional suggestions that we would encourage them to appear remotely. So I think that we don't need to have an actual notice about that. That would be if they are going to appear remotely, staff will tell them, listen, you got to have a secure video and audio transmission and ability so that we can have a regular hearing. I don't think we need to change any rules or publish them about something like that.
Okay, but the staff will have that as part of the checklist.
Yeah.
Yeah, otherwise, like, I don't know if you just heard Carrie said, we could make this really complicated by putting in all these.
If you try and cover every contingency
Yeah.
in the
Right.
notice,
No, I-
notices pages,
Yeah.
it's gonna be really
Yeah.
complicated.
Yeah, no, I get it. Thank you.
Yeah, and before we end though, and before we just approve the minute issue, I just want to say, it's my personal view that we are not a consumer board. We are being asked to change and alter zoning regulations, some of which have been in effect for, 50, 60 years. And we may need to be doing that for specific reasons, for hardship. And in order for people to ask us to say we should be voiding the regulations that apply to everyone else in the town, I think it's incumbent on them to convince us. And that means come before us and not make it be like a consumer complaint thing, the way, you go want to return something to Walmart. And that's just my personal view. I don't think of ours.
Well, I was just clarify that that's not the intent of
Okay.
what I
All
was
right.
trying to say is we are representatives elected by the town. It's our duty to serve the town. And they are considered consumers.
Fair enough. Fair enough. Okay.
So, Mr. Chair, just so kind of wrap it up. So my understanding is the consensus of the board is that it is preferred that an applicant be in person, unless there's for good cause that they cannot be in person. And then that would be reviewed by either the chair or the board at the meeting, whether they will continue the meeting or table the public hearing until the following
Well, I'm,
meeting.
the word preference, it's not that they prefer that they shall be in person unless,
That it would, yeah, thank you.
yeah, unless there's a good cause for them to have to appear remotely. That would be my,
So what,
okay?
Shall,
Shall,
Yeah.
shall, but for good cause shown.
yes.
so what I will do is I will add that text to the application, similar to how we did with the requirement for photos. And then I will send that to the board to review. And if anyone has any objections to the wording, just let me know. If not, we'll just proceed with that.
Right.
Does that work for everyone?
I think that makes sense.
Yeah.
And it should probably, I think, and I think this is part of the majority view, is that it should be that the parties that shall attend in person would be the applicant and or anyone presenting for the applicant, right?
That's true, yeah.
Right.
Applicant and applicant's representatives,
Yeah, because usually it's either or.
yeah. That's true, but sometimes, as somebody pointed out, it was a group and each person knew different,
Yep, so
Thing.
yeah, sometimes you get a combination
yeah.
thereof.
Right. Yeah. For a more complicated or commercial variance, you likely have multiple consultants. Sometimes for a residential application, it's the architect is the one making the presentation or the person that's actually going to be doing the building. It's just the property owner is the property owner. They need the variance, but they're not the expert on it, so they'll have someone else. So just we can phrase it as the primary representative or the main representative.
No, anyone
Shall be.
presenting on behalf of the applicant, I think would be. Right, because we've had one or two where there was, being a presenter, they had one person talk about the landscaping, someone else talking about the configuration, so just whoever is part of the presentation, right?
Right.
That's what we're talking about. All right. All right, if there doesn't require a vote on this, this was a discussion, healthy discussion, I had hoped there might be consensus, but obviously we couldn't get to that point, but that's all right. That's all right. That's democracy. All right. So the next thing on our agenda is the minutes. I'll entertain a motion regarding the February 18th
So moved.
motion so move to accept the minutes as
Correct.
printed. Is there a second?
Second.
All right, Mr. Walsh, all in favor?
Aye.
All opposed?
Aye.
Anyone opposed? Abstentions? All right, so the minutes are approved. If before we adjourn, any applications so far in the?
Not that I'm aware of. The deadline is next week. And then there's always the chance that there's an appeal of an enforcement order, but not
Alright.
that I'm aware of, but I won't know until next week.
Very well. So I'll entertain a motion to adjourn.
Motion to adjourn. Second.
Second by Commissioner Cloud. All right, all in favor?
Aye.
All right. Take care.